So I said that this morning I would respond to your question. It's a great question, but what I want to say is that the 13 states that have an actual provision with their inferior constitution that functions directly to the contrary of the United States Constitution, that's not what's important to focus on. And let me tell you the reason why here. So there's a difference between a constitutional violation that would be a procedural issue, which would require an appeal, a claims processing rule, as they would say in law. And then there's a difference between a facial constitutional violation. A facial constitutional violation means that there's a law that's enacted that directly forecloses upon the procedural situation of the petitioner. So when a state creates a law that functions directly to the contrary of the United States Constitution, that is facially unconstitutional, meaning that that law on its face functions directly to the contrary of the United States Constitution. So a great example is the provision in the state of Washington's Constitution. So Clause 1 of Amendment 5 says no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. So that's clear. You must have an indictment by a grand jury before arresting someone and holding them over for a capital or an infamous crime. However, Washington State's inferior constitution, Article 1, Section 26, says no grand jury shall be drawn or summoned in any county. So the state of Washington has a provision in its inferior constitution that functions directly to the contrary of the United States Constitution, meaning that that particular provision can never be constitutional, and as a result, it is a facial constitutional violation. Anytime that there's a facial constitutional violation, it results in a void judgment, void action. Any action of the state that's facially unconstitutional results in void. It is as though it never even existed, referred to Norton versus Shelby County in the United States Supreme Court. So that would be the difference between a facial constitutional violation. A procedural issue would be such as what we served for Mr. Trump in the state of New York, because when the prosecutor conspires by and between the accuser to deny the accused the right to be present to confront the accusations against them in the grand jury, because that's the purpose of the grand jury, is to protect the accused from hasty or malicious charges by the state, then when they deny the accused the right to the benefit of the proceeding, that would be a procedural issue. However, that is a criminal act, what they committed, and as a result of the criminal act, it results in a criminal outcome, an unlawful outcome, because only right can produce right, wrong will always produce wrong. So when government commits a crime in the pursuance of an outcome, that outcome is going to be unlawful, it's going to be criminal, because it derives from a criminal act. So that's the difference between a facial constitutional violation and a procedural constitutional violation, but either way, it's a constitutional violation. Now, the reason why I say that it really doesn't matter is because 99% of all grand juries, the accused doesn't have the right to be present to confront the accusation, because the state is abusing the process by denying the accused the right to be present to have the benefit of full and equal access of the proceeding. So that is still a constitutional violation. It still results in an unlawful outcome. And that is every single state. Every single state in the country and the entire federal justice system, they all function in that particular manner. So yes, there is a facial constitutional violation in 13 states. That's important. State of Oklahoma, state of Washington, state of Connecticut, state of Pennsylvania, state of Michigan. Those are states that are acting in direct willful defiance of the Constitution. Those are the simple, low-hanging fruit in this issue. But the bigger issue is the fact that you cannot deprive a person the right to be present in the proceeding, because the laws of 1981 state that all persons within the jurisdiction of the United States will have fair benefits and equal protection of the laws and proceedings. So when you deny a person the right to be present to confront the accusations against them by denying them that right, that would be an abusive process. It would be treating two people in like circumstance unequally, because you're permitting the accused to be present to confront the accusations against, or to present the accusation, but you're not giving the accused the right to the benefit of the very proceeding that exists for his protection. So what is information? Well, information started in California, and let me lay it out for you just a little bit here. So what happens is that an accuser calls up the police and says to the government, hey, something happened to me. And then the law enforcement will take that information from that accuser, reduce it to writing in the form of an affidavit. And then that affidavit is considered truth. An affidavit at common law is considered truth. Now the problem is that officer who recorded the information and wrote it down, he's presenting it to the court as though it's factual. But he has no idea if it's factual, because he wasn't a witness. And so when we deal with the Fourth Amendment that states that no warrant shall be issued without a probable cause supported by oath or affirmation, when the oath comes from the officer, it's not coming from the individual that's making the accusation, and therefore the warrant isn't valid anyway, because the individual who's saying that this is factual, truthful, and correct by my oath wasn't a witness to the cause, to the incident, the event. So whatever they say is not valid. Now, what happens with this is that the moment that you're charged by an affidavit, it creates what's known as a trial by affidavit. And that's unconstitutional, because the first issue is that when you're charged by information and not by an individual, then your right to confront your accuser evaporates, right? It evaporates because you can't put that information on stand and cross-examine it, and because it's presented as truth. Now, because it's considered truth, even though that truth has never been confronted, which is the purpose of the grand jury, even though it's never been confronted, you are now deprived of certain liberties. You are presumed to be guilty based upon the mere fact of being charged with a crime. So you're treated as though you're guilty because you're arrested, you're taken to jail, your liberty is deprived, your ability to work and take care of your family is deprived. These are all rights that you have, and you are having these taken away without due process. Now, this goes back to our founding. I mean, trial by affidavit was one of the greatest concerns that our founders had. This was actually what was occurring with the stamp tax starting in 1628, because the king recognized the fact that the stamp tax was so unpopular amongst the colonists that he couldn't get a jury to actually find anyone guilty of that particular crime. So he said, okay, well, if you're not going to find anybody guilty, then I'm going to go ahead and remove common law jurisdiction. I'm going to instill a maritime jurisdiction, right? Which would be what we're under right now. And so, but the problem is when you deal with admiralty jurisdiction doesn't have the right to a trial by jury. That's why, we don't have the right to trial by jury, because we're under admiralty jurisdiction. They switched us to it because it's a court-martial. That's essentially what it is. So, so the king decided that they were doing that, and actually Thomas Jefferson even made multiple mentions within the Declaration of Independence pointing to this issue, where he said that we are subjected to a jurisdiction foreign to our laws. He was referring to a trial by affidavit. He said that in most cases we don't have the right to a trial by jury. He was referring to the trial by affidavit, this issue with the stamp tax. But what happens is that with the trial by affidavit, you are presumed guilty based upon the mere fact of being charged with a crime. Therefore, your liberties are taken away without due process. You're treated as though you're guilty. And that sets up what is called an irrebuttable presumption of guilt. It's an irrebuttable presumption of guilt because you are presumed to be guilty based upon the mere fact of being charged with a crime, right? And so, but the problem is that you've never had the opportunity to be able to rebut that accusation because they've eliminated the grand jury proceeding. So with information, that information doesn't go in front of a neutral, unbiased third party, a grand jury, 16 to 23 individuals that determine whether or not the state's accusations are valid. Instead, it goes to a judge who also works for the state, and he has an interest in ensuring that the state's interests are followed, and so therefore he has an interest in making sure that you go to jail, right? And so there is no neutral, unbiased third party when you eliminate the grand jury. So with an irrebuttable presumption of guilt, what happens is that you are presumed guilty based upon the mere fact of being charged with a crime. Therefore, your rights are being deprived, you're taken away, your liberty is taken away, and you're now treated as though you're guilty, right? And so now this occurs when there is a shift in the burden of proof. Typically, the prosecutor is responsible for determining that you're guilty based upon beyond reasonable doubt. That's the responsibility of the prosecutor. But when you have an irrebuttable presumption of guilt, what happens is the burden of proof shifts, and it's now the defendant's responsibility to go out and collect evidence to prove that they're innocent, right? So it's no longer innocent until proven guilty, it's now guilty until proven innocent. It's a complete shift in our complete legal theology that we have today. You are presumed guilty based upon the mere fact of being charged with a crime. You must then go out and collect evidence in order to prove that you're innocent, right? The prosecutor no longer has to prove that you're guilty beyond reasonable doubt. And according to Blackstone, this particular issue, it occurs when there is a breakdown of due process and the system focuses on speed and efficiency as opposed to established procedures and processes. There's absolutely a breakdown of due process that's occurred because the very first step is not being followed. It's being disregarded because of what's called information. Information cannot be the charging instrument. That's in direct violation of the United States Constitution. And not only is it in violation of the United States Constitution, but this issue, never, ever, ever does a defendant have to prove their innocence, because that's not only a violation of the United States Constitution, but it's a violation of international human rights standards. Never, ever, ever does a defendant have to prove that they're innocent. And as a result, everything that's happening, all these cases, all these convictions that these states believe that they have, they're not valid. They're completely without force or effect in the parties involved in dispute because they derive from an unconstitutional act committed by the state itself. God bless you guys. Thank you so much. Continue to follow me. Please share. If you guys have the ability, please donate to the tour. We need the funding very, very badly today. I'm going to go to work, and I'm going to believe that we're going to be able to have the money that we need to be able to have a place to stay tonight. God bless you. Thank you so much. Have a great day. Okay.